Hi, everybody. I'm Dinesh Chawla. I'm one of the co-founders of this school community, Cover Your Assets, also known as the CYA community. So this is our estate planning 101, kind of an intro to the essential things that the foundational documents, I should say, that we use for everybody across the board. So if you turn 18, first things we want to do is put powers of attorney in place to maintain control over your decisions during your lifetime when you're sick but not dead. Okay, remember our three phases: alive and well, sick but not dead, and then dead. The powers of attorney address the sick but not dead phase. Now we're going to address a little bit the dead phase. So before I get into this, I always forget to say this, but I should. Just because I'm an attorney, it doesn't mean everything that comes out of my mouth should be considered legal advice. Okay. I'm not your attorney. I am an attorney in the state of Michigan, but everything I'm going to be talking about are general legal concepts. Okay. These are true everywhere. If you want to get more specific, I'm more than happy to consult you in one of our private sessions or introduce you to the right lawyer. I've got a network of estate planning attorneys across the country that can do exactly what I do and are in tune with exactly what I do. So let's get into what wills are. One of the common misconceptions about wills, or a couple common misconceptions, are that they avoid probate and that if I have a will, everything is going to get to the people that I need it to get to with no issues or hassles involved. Well, that's not necessarily true. The will is a document and it's also a tool. Okay. If you use the tool properly and it's coupled with what it's meant to be coupled with, then the will is a very, very powerful tool. All right. So, first and foremost, the will alone will not help you avoid probate. Okay. The will alone cannot avoid probate. That's not what it's intended to do. What the will is intended to do is when you die, it is intended to speak on your behalf to the probate court. Okay. So that means that the only way we would even need to worry about a will is if you have a probate estate. And that means when you die with something in your name. So if I die and my house is in my name, or I die and my car is in my name, or I die and my bank account's in my name and it doesn't have any beneficiary designations on it. What if I have a 401k with no beneficiary designations on it, or a brokerage account, or an insurance policy, or an annuity, and none of them have beneficiary designations on them? That all goes to my probate estate because when I died, it was in my name, ownership, title, whatever you want to call it, that was in my name and my name alone, no joint owners. So I now have a probate estate. I also have minor children. Minor children, if you're a single parent or you're the it maybe me and my ex we get along very well. So maybe we're in a car with each other and there's a crash. If we both pass away, where do our minor children go? So that's one of the concerns that a will addresses through the probate court is it appoints a guardian for your minor children. All right. So here's less of a teaser and exactly what the will does. I have a will. So when I die, everything that's in my name is considered a probate property. And let's pretend like my ex-wife is out of the picture completely and my kids now need a guardian because they're minors. All right. So I get to pick who I want to manage my estate. That's what we call a personal representative. In some jurisdictions, you'll hear it referred to as an executor, but in Michigan, we call it a personal representative, and they are representing the estate as what we'll call the manager of the estate. All right. Then I can also, in my will, appoint a guardian for my minor children, and the personal representative will make sure that the guardian is properly in place. They'll guide everything through the courts. And then I can also, as an instruction, put what I want to be included in my probate estate, any special gifts I want to give to people, any special instructions I want to make, I can use in my will, and I can also state and determine who I want my heirs to be. Okay, so the will is actually a playbook. It's an instruction manual. And the court has its process, its decedent to estate probate process. So when you die, if there's anything in your name or guardian or minor children, you're going to go through this process. Now, the court has its own rules, and those are the government rules. And usually when you're going through probate, you're going to walk in and there's going to be a room with a bench, and there's going to be this person in a black robe. And that person gets to use their rule book to decide all these things for you. Who is going to manage your estate? Who is going to be the guardian for your minor children? What all is going to be included in your estate, and how are we going to distribute that? Okay, so that judge gets to use their rule book, if you don't have a will, to determine all of those things, and then say that they're doing this in your best interest. Okay, but what do they really know about what your best interest is? Like right now, according to court rules, if me and my ex-wife both pass away, the best interest of our children would be best served by my sister. But what the court's not really going to look at is my sister is, yes, is she a good mom? Yes. Is she a good person? Yes. Does she have a good job? Yes. Does she have a dwelling? Yes. But my sister also has two boys that are the same ages pretty much as my boys. So now, and my sister's also single. So I'm going to straddle my sister with the burden of 4 boys between the ages of 6 and 12. That's not fair to her. That's not fair at all. And it's not something that I would want for her. Again, I love my sister, and I believe that she would be a great parent for my kids should that situation ever come up, but it's not in their best interest to be in that environment when there are other people that we can rely on for that. So that being said, the court doesn't really understand what your best interests are. That's where the will comes in. If you have a will, and part of this process is to give the court your will so they can validate it, but once they've validated your will and said, we're going to accept this, now your playbook, your instruction guide is what is going to guide us through their process. Okay, so that's what a will is. It's simply an instruction manual. It has nothing to do with probate avoidance. It has nothing to do with asset protection. It is just your instruction. So this all goes back to one of our key elements that we talk about a lot here. Estate planning at its fundamentals has nothing to do with assets. It's all about control and protection. Okay, so those are the 2 key fundamental things in estate planning: control and protection, which is exactly why we're able, because it doesn't have anything to do about assets, it's why we're able to show you how to play like the rich kids. It's taking the methods and the tools that they use and just scaling it down for our middle class needs. Okay, so that's why we've developed, based off standard general rules and techniques and strategies for estate planning, for the high net worth individual, we've just scaled that down and made it more in tune with the needs of the middle class, and it attacks the issues of the middle class and helps us develop solutions to get us out of the middle class. So again, I'm Dinesh Chawla. Enjoy this school environment, and remember to cover your assets.